How would you feel about facing a trial without a jury? Because that is precisely what this government is now suggesting tentatively as an intermediary court to deal with the Crown Court backlogs, which currently stands at about 70,000 cases. So I'll talk a little bit about that in this video and the ramifications that it might have. But first of all, if you wouldn't mind subscribing to my channel, because my little fella at the back there, sitting there for Christmas, suggests that you subscribe to my channel for an objective, neutral approach to the news and the law and what's going on in the country. So I'll be really grateful if you do that now. So what on earth do we have going on here? So we have a proposal to have a new intermediary court. Now, bearing in mind, we already have the intermediary track for civil claims introduced last year, but this new proposed intermediary court for criminal cases would see a judge and 2 magistrates sit on cases where the sentence does not exceed 2 years for offences such as dangerous driving, other minor assaults, but including assault on police officer and various aggravated crimes such as racially aggravated criminal damage and things of that nature. All of the serious offences, of course, would still go to a jury trial, but this has been suggested to relieve the backlog of the less serious offences. Bearing in mind they've currently released a lot of prisoners early because they're running out of spaces, or they've already run out of space by the sound of it, and so they had to release some prisoners to free up some space. This would probably then accelerate the process of putting people back inside, which to me seems a little bit counterintuitive because it's sort of one in, one out. If they're letting people out to let people in, and then they introduce an intermediary court which lets more people in, then they need to let more people out, and we're just going to go around in circles unless we solve that problem. So straight away, even talking this through, I don't really see this as a proper solution. Proper solution perhaps in dealing with the backlog, but not a solution in dealing with the underlying problem. Now, the right to a jury trial dates back to Magna Carta. Watch the comment section go absolutely crazy. 1215 declared no free man shall be seized or imprisoned except by the lawful judgment of his equals or by the law of the land. Now, this principle is even further protected under ECHR Article 6, ensuring the right to a fair trial. Now, ordinarily, a court that sits with a judge and 2 magistrates would otherwise be an appeal at the Crown Court. So, for example, you are convicted in the Magistrates' Court, you have an automatic right of appeal to the Crown Court. You don't get a jury, but you get a judge and 2 magistrates, which, when you get there, it's effectively a rehearing by the judge and the magistrates. They essentially hold another trial, and the judge will rule whether or not you should be convicted or not. But bearing in mind that when you go to an appeal to the Crown Court, you're sort of already there on the back foot because you've already been convicted in the Magistrates' Court. But we digress. Now, the potential benefits, obviously, of this proposed reform is that it could remove around about 10,000 cases from the Crown Court backlog, which would significantly speed up the delivery of justice. But what sort of justice would that deliver if you have a judge and 2 magistrates? Where would you appeal? Then that obviously then leaves an open question, because if you've already had this hearing by a judge and 2 magistrates, that would ordinarily be an appeal. Where do you go from there? Just the Court of Appeal, perhaps? Now, bearing in mind we've already had a back and forth about the increase in sentencing powers for magistrates, which was essentially designed to do the same thing, this really does need to be very well thought out and well structured if this is going to succeed. Now, there's been a lot of different perspectives on this. The former Justice Secretary, Alex Chalk, KC, says this court would take an additional cohort of prisoners out of the Crown Court, further easing the pressure and securing rapid justice for victims. Because as the saying goes, justice delayed is justice denied, and there are lots of people waiting for justice because of the 70-odd thousand cases in the current backlog. He also argued that jury trials are the Rolls-Royce of the justice system, but also said if you want to preserve the value and the quality of the jury system, something has to give, because at the moment it's being degraded and is not delivering justice, because, as I said, justice delayed is justice denied. None of this, however, is to underestimate the fairness or the perceived fairness of the justice system if the jury trials are removed, even for offences with sentences only up to 2 years. Lots of people will criticise this approach, saying that it will undermine centuries-old principle of trial by jury, which many see as a fundamental right to justice in the UK legal system. Any changes, therefore, obviously will have to strike a very careful balance between the efficiency of running these trials and the right to a fair trial. And finally, I have to say that I was reminded to talk about this by the Magistrates blog, so go and check that out. I'll link it in the description below. It's a very interesting read. But also let me know in the comment section, how do you feel even for lower grade offences, how would you feel about going to a trial with a judge and 2 magistrates instead of a jury trial, when you could be facing a prison sentence of up to 2 years? Let me know what you think in the comment section below. Please do remember to like the video and subscribe, if not just for my little friend back there who's sitting there for the duration of Christmas. And as always, thank you for watching.